Hi, everyone. I'm Peter Dahlen, the Managing Director for the American Chamber of Commerce in Sweden, and so welcome to the American Garden. We're proud to be working with the Swedish Anti-Corruption Institute and Transparency International in Sweden together on, Together Against Corruption, an initiative we started in, I think, 2014. And it's an important initiative bringing together the private and public sectors in a positive cooperation to share best practices in combating corruption. And as everyone here knows, fighting corruption is key to good governance at the heart of developing and reaching the environmental, social, and governance or ESG standards that are much talked about throughout the week here in Almedalen and elsewhere as well. So in this section, we're going to, which is called the Long Arm of U.S. law, we're going to look at U.S. legislation on bribery because global implications for businesses and functions as a deterrent against corrupt practices. And as you know, Swedish companies have been sanctioned by U.S. authorities for bribery and then subsequently entered into long monitorships. And we'll take a look at what those agreements mean in practice. So we've got a great panel of experts with us. So I'm going to go in alphabetical order. So starting with Adria Perez, who's joining us online as a partner at Kilpatrick, Townsend, and Stockton, and she's joining us from Atlanta today. She's a member of the Government Enforcement and Investigations team and serves as co-leader of the firm's environmental, social, and governance practice and focuses her practice on representing clients in white-collar criminal defense matters, government enforcement issues, as well as internal criminal and Securities and Exchange Commission investigations. Her experience includes handling issues related to the Foreign Corrupt Practices Act, Commercial Bribery, False Claims Act, environmental crimes, and civil investigative demands. And she assists clients in responding to inquiries from government investigations and also counsels clients on developing and strengthening compliance programs and policies. And Adria is joined online by Barak Cohen, who's joining us from Washington, D.C. He's a partner in the white collar and investigations practice at Perkins, Coie, and chair of the firm's cannabis law group. He represents companies and individuals facing government enforcement investigations in highly regulated industries and companies that need strategic business advice regarding compliance and regulatory matters. He also works with the firm's digital media and entertainment, gaming, and sports industry group. What's more, as a former prosecutor in the Department of Justice, Barak's led numerous investigations and has sort of inside experience on diverse matters that touch on foreign and domestic fraud and bribery, financial misconduct, tax crimes, and more. He also has represented multinational companies in sensitive international investigations involving international corruption laws, such as the Foreign Corrupt Practices Act and the UK Bribery Act. We also have joining us live in Almedalen and Visby, Hayaat Ibrahim, who is the Secretary General of the Swedish Anti-Corruption Institute. And I also want to note it's Hayaat's birthday, so please join me in wishing her a happy birthday. Happy birthday, Hayaat. Thanks for taking the time to be with us today. And so the Institute works to promote ethical decision processes within businesses as well as within the rest of the community and to prevent the use of bribes and other types of corruption as a means for affecting decision processes. She's also a columnist at a leading Swedish publication on sustainability, and prior to joining the Anti-Corruption Institute, Hayaat practiced law at Dinga, where she specialized in anti-corruption, internal investigations, entrepreneurship, and human rights. And finally, we have Ulrik Åshuvud, who is chair of Transparency International Sweden. He's an international lawyer with a passion for process management and quality assurance of both justice and migration processes. And he has broad experience from different management and expert positions in the field of justice and home affairs, beginning, I think, in 1994 with the Swedish Ministry of Justice. And that's old, yeah. Yeah. And the Swedish Migration Agency, it doesn't show. And so he's led multilateral operative cooperation frameworks and been a lead consultant as well as the head of delegation for several international assignments in the field of justice and migration. He's also the founder of Just Develop, which is a management consulting firm specializing in justice and migration management. So with that, let's go to, I start with some questions. I think it might be a good idea to start with some basics. So I'm going to turn to our guests online first, and just kind of starting with, why is fighting corruption important for the United States? And also, Barak, I think I'll turn to you first, and then if you could also maybe describe the difference between the Department of Justice and the Securities and Exchange Commission.
Sure. So the importance is really twofold, and actually it's an interesting question to be asking now, because the Department of Justice has just issued its 2022 to 2026 strategic plan. So traditionally, fighting corruption internationally has been a goal to help maintain a level playing field for businesses, particularly American businesses. The Department of Justice doesn't want companies competing in a way that's inefficient and that skews a capitalist market. And they want business to work efficiently and based on substantive qualities that businesses are bringing to the table, as opposed to bribes. What's interesting about the strategic plan that was just issued, the 2022 to 2026 strategic plan, is that the same kind of focus on international corruption is there, but now it's being articulated in terms of national security. So what the Department of Justice is emphasizing is that international corruption helps undermine national security by empowering foreign dictatorships, kleptocracies, and it's a different kind of focus. I found that interesting. As to your process question, the difference between the Department of Justice and the SEC. So the Department of Justice is the primary executive agency empowered to enforce U.S. law and administer justice, the justice system. It's not just criminal law that the Department of Justice administers, it's also civil enforcement, but it is the agency empowered with criminal enforcement. The SEC has a very, very focused mission, and first of all, its primary tool is civil enforcement, but that focused mission is to enforce against violations of the Securities Act and to protect investors and market manipulation. Very, very U.S.-centric, very, very capital-centric kind of focus.
Great, thank you, Barak. And Adria, please feel free to add to that if you'd like on why the U.S. focuses on fighting corruption, and also if you could maybe talk to us about or explain the basics of a deferred prosecution agreement and how they work.
No, I'm happy to. Thank you, Peter. And Barak is absolutely right. This shift of deeming corruption to be a national security issue is a really important one. And, getting bipartisan support in the U.S. Congress for the Democrats and the Republicans to agree on anything is very, very difficult these days. But one thing they do agree with is the importance of national security. And so what comes with that is money. Congress will allot or allocate more money to something like national security, and more money means more resources for the DOJ, more FBI agents, more FCPA unit lawyers, more resources as far as wiretaps and being able to cooperate more with other countries like Brazil and France and the UK and whatnot. So deeming corruption to be a national security issue is really important for companies to understand. I will say too, one thing that my companies or my clients understand is that the FCPA is a cost center for the DOJ. It brings in money to our U.S. Treasury, a lot of money to our U.S. Treasury. And so because of that, it's a priority, and it still is a priority based on the strategic plan. So that's important to know. I will say just a little bit of just the basics of a deferred prosecution agreement. But even before those negotiations even happen, it's really important for companies to understand what did happen. Like what are the facts, and really understanding, getting their arms around everything that did happen, And the government does look to whether the company did voluntarily disclose the issues and completely and thoroughly. And so it's really important to understand all those facts. And companies who are in a position of possibly getting a DPA, they have cooperated, they've given information, they've given interviews through employees or agents, and they want to get that DPA because it's a great mechanism for many companies to defer the prosecution. I mean, that's what it means. And so what the government looks to is, do they want to get into an agreement that a court has to generally approve, where prosecution is going to be deferred for a period of time, usually 2 to 3 years, but more often than not 3 years these days. And the company has to agree to pay a fine and to continue their cooperation, and to also waive the statute of limitations, and has to also agree to certain requirements, compliance tasks or requirements that have to be done in a certain amount of time, and then possibly even agree to a corporate monitor. And I was one of the leaders of the Volkswagen AG independent monitor and compliance team. That was a 3-year monitorship. And I can tell you that's a real burden on a company to have a compliance monitor, but it does create real and significant change in a short amount of time. And Volkswagen was very successful in what they did. That was not a DPA, that was actually a plea agreement, so it was a different vehicle, but they were required to have a compliance monitor as well.
Interesting, thank you. And then, so what is the impact that's felt in Sweden? Do you think, like, starting with you, Hayaat, of U.S. anti-corruption law, or like how does it correct imperfections in how companies in Sweden might act?
It's definitely puts a lot of focus on the issue of corruption and foreign corruption here in Sweden, and prior to the more recent corporate scandals that we had involving, for example, Telia and Ericsson, the newspapers didn't really report about corruption in the same extent as they do today. And I think a lot of that has to do with the consequences, and many people are questioning, how is it possible that U.S. authorities are driving this, and why are Swedish authorities not being as active? But also, like, how is this possible? Swedish companies are not U.S. companies. Why are these authorities involved here? So I think many people don't really understand that. But aside from that, I think, from our perspective, when working with, Swedish multinational corporations, it's specifically when talking to, for example, chief compliance officers or general counsels, see that many of them are happy with this new focus, because they've also previously been met with kind of a lot of pushback from the businesses and the corporate functions. So by having these kind of examples where Swedish companies have also been forced to pay these kind of amounts, is also something that's resulted in a different type of conversation internally within the companies, and it's kind of giving some heavy weight to the arguments that the general counsels or even the chief compliance officers can come with. So from my perspective and from the institute's perspective, it's actually been very good when it comes to driving the conversation. So yeah, but I think we need to also explain more why this is happening.
Right, so it makes clear on the business side the cost of non-compliance. So
I think many are, partially aware of the cost, not just when it comes to the corporate fines, but also, in terms of the legal costs, internal investigation, but also, as we've seen here, when it comes to the stock exchange market here, we see that, some of these companies, their stocks have reduced value by 20%, 30%, when we've seen different kinds of allegations come to light. So I think they are definitely feeling the pressure, and it's more the U.S. that is driving this than the Swedish legislation, unfortunately.
interesting. And then, so Ulrik, why do you think like Swedish companies are sort of overrepresented in those?
Well, we can go back to the statistics a bit later in terms of. Hello.
Hello.
Hello. Are you there? Yes. It's the speaker, I think.
That's the chair.
Are you okay? Everybody alive?
It's a little jump scare.
Yeah, okay, right. Preventing you from saying something both possibly. What I think is actually, you can see it, see difference over the last 5 years, maybe 10, but I would say particularly the last 5 years, where companies, Swedish companies are taking this as an important part of their overall work as such in the ESGs that we were talking about, but not just that. It's actually good for business to work with anti-corruption. That is a big change. We can see that in our business integrity forum, where we have 23 multinational companies, Swedish companies with us. And the dialogue you have there is very, well, it's both technical. Yes, and we do talk about the DPAs, and I'll get back to that. That's a deterrent. Nobody wants to be there. And nobody wants to pay that fine or that sanction. And for Ericsson, it's cost a lot of money. We know that, and it's probably going to cost them even more at this point. But that is outside the picture. Yet I could say that American prosecution, or lack of prosecution in this case, because it's a deferred prosecution agreement, is a deterrent, but that's not the whole thing. So the climate and the culture within the Swedish companies has changed. But this is obviously helping out at the same time. Now, why did they end up in the DPAs? Well, that's because they're on the American market or the American stock exchange, or dealing with US dollars in a large amounts and stuff like that. That's why they act under the US law, not because they just happen to be corrupt. So there is, I mean, you don't end up with the DPA. I should probably not move.
Yeah.
Yeah, they don't end up with the DPA if there's no link to the US exchanges or the actual stock exchange.
Right, so then that sort of leads to the question of how do you get noticed by the DOJ? Like, if you don't self-report, I kind of a two-part question, maybe starting with you, Barak. If you don't self-report, are you still able to get into a DPA? And how do cases normally come to the attention of the Justice Department?
So obviously, if you self-report and you cooperate prolifically, you are likelier to get a DPA or likelier to earn some goodwill from DOJ. Nevertheless, it's not impossible to get a DPA. And also, we haven't talked about NPAs, non-prosecution agreements, but those aren't impossible either, and are actually preferable, or at least my clients prefer them for pretty obvious reasons, because courts aren't involved. So no, it's not impossible to get a DPA, it's just a lot less likely. To the extent that companies cooperate, lean forward, appear to be acquiescing to DOJ's desires, they're going to be able to get DPAs, and they're going to get preferential treatment. Having said that, there were certainly times where I've been very, very skeptical in how I view DOJ's efforts to assert leverage over companies. As to how DOJ becomes aware of cases, there was an old joke I remember when I was a federal prosecutor. Anytime we would get a case, it was typically always, quote unquote, the lowest hanging fruit. Some whistleblower would come in because they're irritated about something that, frankly, even from the perspective of a prosecutor, isn't particularly important. And it could explode into an incredibly big case, because slowly, as the facts come in and DOJ investigates, some bribery scheme starts to unravel, and DOJ realizes there's some multinational bribery effort being undertaken by some company. That happens. That happens often enough. So whistleblowers are a common way for cases to come in. Sometimes there are more altruistic whistleblowers. I've had matters, for example, in Russia, where we've had local employees who were very sincere in their desire to point out corruption. But typically, it's the lowest hanging fruit.
And thanks, Barak. And Adria, do you have others? Have you experienced other sources of?
Right, I've had everything, just like Barak said, from internal whistleblowers. Even now, I'm seeing more of a trend of people in significant positions like the head of internal audit or the head of quality assurance becoming a whistleblower, and not so much someone on the ground, but actually someone who has a lot of information that could be helpful to the government. I've had competitors reach out to various governments, and then those governments reach out to the United States Department of Justice. In Russia, I had an issue where actually there was an accident at a factory, and once that was unwound, then there were issues with corruption. During COVID, I actually had suppliers or vendors of clients send letters from China. So these whistleblowers were suppliers and vendors, and they were sending, via normal mail letters, saying that there were issues. So it can come from various sources. I will say too, my clients have been interested recently. There's a short seller research company called Hindenburg Research that does these exposés or these reports on various companies, and they obviously are a short seller, so they get some benefit by making sure that the stock price goes down when they issue these reports. But the DOJ reads those reports on Hindenburg Research's website, and they have started at least 8 investigations over the last 2 years based on Hindenburg Research's expose, and several of them have to do with FCPA and international corruption issues. So, and even ESG issues now. So it can come from all sorts of different sources for sure.
And could you sort of repeat that? The Hindenburg Research, is that an NGO or it's what is it?
No, it's a company in the U.S. It's a short seller, but they call themselves a research company. And if you go onto their website, you'll see all these various exposés and reports on all these companies, including DraftKings, Lordstown Motors, Nikola Corporation, Ormat Technologies. It goes on and on and on. And so, and the DOJ does read those, and the SEC, and they have issued subpoenas after reading those reports and started investigations.
Interesting. So both of you would like to comment. So Ulrik.
Yeah, I have a question actually, and a more comment as well, but more of a question in terms of when you have a DPA and things are moving ahead, smoothly somehow with the monitorship as well. But if things are not going so well, how likely is it that it will actually turn into prosecution? Do you have any understanding of the statistics on DPAs being then finally in the end prosecuted anyways? Is that common or not? Who wants to?
I can take that. So I wouldn't exactly say, I don't think it's particularly common for referrals for prosecution. And the reason I don't think it's particularly common is because it's not impossible for sure, it happens. The reason it's not particularly common is by the time DOJ has entered into a DPA, a lot of work has gone into a DPA, and there's mutual bilateral buy-in to the process. A lot of effort gets invested. Line prosecutors will have completely vetted it. They will talk to supervisors. A lot of memoranda will have been written. And it takes quite a bit of work to actually flip that and make it into an active prosecution. Again, that certainly happens, and I would never advise a client to risk it. But because of the effort involved and the amount of commitment that's already gone into managing the DPA, it takes more than you would think for it to become an active prosecution.
Just another question. Would you say that a DPA is a fair rule of law procedure? In a sense, because you never get to you never get to normal legal procedure. And then you actually pay a big sanction on top of that could be seen as not a bribe, but you're actually paying for something to get out of it.
So first of all, I have to acknowledge it's ironic for me to be taking a position on behalf of DOJ because I spend 100% of my time advocating for clients. So I would respond to your question the way I would discuss it with a client, which is we have a problem. We have a DOJ problem. We have an SEC problem. We can fight this on principle if you'd like, but we're all aware of what the evidence looks like. How do you feel about a DPA and the practical problems and the practical benefits? So when I'm talking to clients about it, it is a very, very pragmatic kind of discussion. And so obviously what you're asking is a principled question with respect to legal process. That's not even the framework candidly, it's not the framework I typically deal in when I'm advocating on behalf of clients. So it's a difficult way to look at things. But I take your point, and I tend to agree with you. It's not entire, equities are missing, legal process is missing. The court is obviously involved, but DOJ has tons and tons of leverage. Nevertheless, I will often advise clients that a DPA is the best way to go.
And that's some of the discussions we're also seeing here in Sweden. In many cases, some of the companies say that, it's purely out of commercial reason that we're going forward with this, because the US is such an important market for us. So we'd rather handle it in a practical manner than just, go to court. But just like Ulrik here is saying, I think that's quite questionable when looking at, for example, here in Sweden, we've had some court cases where, it's been acquitted, but in the US, you've also collected very large, high fines. That also, as you mentioned earlier, your colleague here, that's also, funding the US authorities.
But maybe we should get a bilateral agreement between US and Sweden, so we can share that sanction.
Yeah.
So we get 50% of the sanction, at least to the state.
We can get that if you're the whistleblower, right? So,
Right.
but looking at so the US was sort of a first mover when it came to the Foreign Corrupt Practices Act, and now we have the UK Bribery Act. Are there things that are there ways we could that the US could improve their Foreign Corrupt Practices Act, or that Sweden could improve its legislation? I mean, this is basically a question to everybody, so I'll just throw it out to whoever raises their hand first. Anyone want to?
The Swedish legislation is quite weak on this, that we know. We have issues with, we have a new piece of legislation which has not been really applied yet because of the cases that were too old. We had people that were acquitted just about a week. Out of the Ulrik case, Ericsson, there were 4 managers that were prosecuted and none of them were sentenced. But now that's being appealed, which is quite interesting to see what that would lead to. But on the other hand, internationally, somehow Sweden will be mocked. Looking at, we have already a DPA ongoing with this company. They have a monitor. They know they've already agreed to say, well, we did do this in Djibouti and other places. So that's not the question. But to get anybody accountable for that has been an issue with the Swedish legislation. Hopefully within a year, if we get to apply it in the future. The case was too old. That was well, it was old enough to be within the old margins of the old legislation. That was one of the reasons. But that has happened now again, and the same thing happened with Telia. And obviously, internationally speaking, people look at Sweden and say, well, what's going on? Because since you can't send, people have actually already said that they have done this. So why can't you get a due process in Sweden to function? So that, in a sense, the pressure being kept up by the DPAs and the DOJ, definitely not, it seems like the pressure will be higher with the new strategy and the plan somehow, also linking the strategic plan linked into national security. It's not going to be less. As you said, you have more resources. That will probably also assist Sweden in being better at this in the end. So I think we need to get the Swedish legislation up, the standards in Swedish legislation, but in particular also the resources spent on the prosecution. There we also have a lack of resources for the prosecution.
But also, like from the period effect perspective, with being criticized for having very low corporate funds, for example, for quite some time by the OECD, for example, we recently had the corporate fine raised with 5,000%. Sounds a lot, but it was 10 million. Now it's 500 million Swedish kronor. So that's nothing compared to what these transactions and business are worth when they're conducted in many of these emerging markets. So from a Swedish perspective, it would probably still be seen as a commercial risk. Many companies would be okay with taking. But now, given the types of corporate fines that we've seen in the US and the UK Barak, it doesn't even have that limit. that's definitely put pressure on the Swedish companies, but I think that's also something that we need to look more into from a Swedish perspective, alongside with more resources for the prosecutors, and also, you know, when we have a case, let's take it all the way. For example, when it comes to the Telia case, I mean, there were indications of bribes having been paid after the new legislation entered into force, but that was not something that the prosecutors actually took to court. So unfortunately, we didn't get any type of jurisprudence on our new offenses.
And so if somebody is prosecuted in Sweden, is there any chance that they would potentially run afoul of the Justice Department? And this, there's sometimes problems in other areas as well, like conflicts between like reporting requirements for like FinSec, like I can't remember what that stands for in the U.S. Like companies, particularly like international companies, when they have to choose between compliance measures in Sweden versus compliance measures for like the Securities and Exchange Commission, that they will comply with the SEC. Because the repercussions for not complying are so much higher than failure to comply with Swedish law. So there's some specific instances of that being applicable for financial reporting, but are there any instances where, or any cases where that might occur when it comes to bribery? Like if you're going to self-report, if you're a big Swedish company and you self-report, did you face like double jeopardy, as it were, like a legal process here in Sweden and legal process in the U.S.?
Well, the persons are normally prosecuted in Sweden. It's not the company being prosecuted at this stage. That's the problem.
I mean, in Sweden, you know, a company, not like in other countries, or Sweden doesn't really allow for companies to be found guilty of a crime. Only physical persons can actually commit a crime. So I think that's also an issue, and that's more of a, you know, a legal cultural history that we have here in Sweden. And so that's also kind of a mindset question, I think, compared to, for example, if we look at the UK Bribery Act, where we have the failure to prevent, and where there is a very clear responsibility for the companies. So I think that's also just, you know, from the way that our legal system is structured, that's an issue in itself. But when it comes to, you know, voluntary disclosure, actually we have that in the Swedish Penal Code. If you voluntarily disclose, for example, bribery, in the case that you would be subject to a corporate fine, you know, that they could actually decrease that even down to 0. But, you know, the act of voluntarily disclosure, it's not something that's very rooted in the Swedish culture. We tend to keep everything very close to ourselves. So I think, you know, the US has really demonstrated why companies should self-report.
Now, I want to bring up something in terms of disclosure and transparency. In terms of under monitorship, and turning to you on the other side of the ocean, if you have an ongoing monitorship, how transparent can you be in terms of for the public? I mean, we see that as an ongoing discussion in Sweden with certain companies that have issues with ongoing monitors there, and they keep on saying we can't say anything because we have an ongoing discussion with the Department of Justice. It's not, we can't say anything basically. We get back to you, and then we never hear anything anyways. So what's your recognition about that?
Well, as a former monitor team member, you know, we don't make recommendations to the company about what they can reveal to the public or not. Honestly, it's up to the company whether they want to go down that road or not. I will tell you though, if an offense happens during a monitorship, if there's another crime or another issue, in the DPA or the plea agreement or whatever vehicle that's used to implement the monitorship, there is a notice requirement to the DOJ if something happens, and a notice requirement, honestly, to the monitorship. And I know when I reported to Larry Townsend, the monitor for the Volkswagen monitorship, and he was also the independent auditor, He had a saying of no surprises. He did not want to find something in the Financial Times or the Wall Street Journal. He wanted to hear from the company. And usually his first question would be, did you tell the DOJ? So there is a huge incentive for the company to be very transparent with the DOJ and the monitor, for sure. But to the public, that's not something that an independent monitorship would get into.
I think that's just to follow up on that question. The question and discussions that we've had in the Swedish community has also been about, if something comes up, such a new allegation, or that you've paid bribery in a certain company or in a certain jurisdiction, should you report that to your monitor or directly to the DOJ?
It's really both. It's really both. And because honestly, the DOJ is going to ask me, well, do you think their compliance program is enhanced enough now to stop that from happening again? I'm going to get all sorts of questions about the compliance program itself. The company is going to get a lot of questions about intent and all sorts of other things, right? But you really should be telling both, because the monitor has to certify at the end that, it depends on the language, but the key language in these vehicles, whether it's a plea agreement or DPA, is, does the compliance program reasonably and effectively detect and prevent? And then there's the crime, either corruption or fraud or what have you. It could be a myriad of things. And that's what the monitor team is going to be asked about. The company's going to have to give more information to the DOJ about what happened, how it happened, is it going to happen again? And I don't know, Barak, if you would like to add anything there.
No, I think you did a really nice job of covering it. The one thing I will add is, as you were speaking, I was going back to the earlier question regarding legal process and DPAs. So candidly, I've never, and I've worked on monitorships, and I, like you, Adria, when I've been involved in monitorships, I've taken them very seriously and I've tried to do my job. But I'm always very skeptical of this notion that DOJ is using a private actor as a proxy. I mean, I'm happy to do the work and take it seriously, but the interests can get a little conflicted, even when you're trying to do your job really well. And I hate feeling like a proxy for prosecutors. And I know of the fraud section of DOJ will occasionally try to use monitors as proxies. They will try to use monitors to conduct mini investigations on behalf of DOJ, and it just disturbs me.
Yeah, that is a disturbing problem, Brock. You're right about that. Monitors are in the monitor team. They're not investigators. Okay, they're really focused on process and culture. Okay, and making the company a better company. We are not looking. I'm not looking into facts or intent. When my clients call me and say, "Hey, Adria, we think there's a problem in Russia or China. Can you look into it?" I'm a fact finder, and I'm looking to see, do we have a problem, and do I need to go to the DOJ and the SEC and beg for forgiveness or not? But we are definitely not. We are not a government authority as monitor team members, for sure. And I agree with Barak. I would never want to be in that position, for sure.
Thanks for that. I think that's a good clarification, especially for people who don't know what the monitorship is about. Yeah. So
I just want to follow up on that. I think that was very helpful. But looking into, if you have a company that is actually under monitorship, I'm not mentioning which company this is, obviously, but they're under monitorship, and things come up, and they get a formal letter from DOJ and a formal press release from DOJ saying, "Hey guys, you're not fulfilling the agreement." What happens then? What is the next step in such a process? Do you have any experience of that?
So it's possible at that point under a monitorship, and if the DOJ has sent a formal letter to the company saying you've got problems and we're concerned, if it's a plea agreement where the company's on probation and there's a judge involved, very involved, it's conceivable the DOJ would go to the judge and say, we're very upset and they breached their plea agreement and they shouldn't be on probation and we need to go after them for more money, right? Because it's a company. They can't go to jail because it's a company, it's an entity. So it would be more money. What I usually see is that the DOJ would prefer not to do that. And honestly, for some of the reasons that Barak mentioned before, they want to find a resolution. And so then it could be extending the monitorship, making it longer. It could actually be extending the scope of the monitorship to look into other issues. There's a whole host of other things that could happen with the monitorship, using the monitor to make sure that that new thing that the DOJ wrote about would not, there's a lower risk of that happening again. And let me just be clear, and I know I sound like a defense attorney now, but if you work at a big company, you're going to have problems, and you're going to have problems during a monitorship. It's going to happen. That's reality, because companies are made up of people, and people do not so smart things and make stupid decisions sometimes. And so you have to be, as a company, you need to be aware of that when you're negotiating some of these agreements, but also be aware when you have a monitor that, you know, it's better to be transparent because these things come up, and I think most monitors expect that. So.
But
I think that's an excellent point. I'm sorry.
No, go
I was
ahead.
going to say, I think that's an excellent point. Big companies will always have problems at some level, no matter how robust their compliance programs are, and you hope that you've negotiated in advance some wiggle room, so that and that you're dealing with prosecutors and regulators from the SEC who are thoughtful enough to appreciate that companies struggle with compliance, and that it takes real effort to create compliance programs. I have been on monitorships where additional problems popped up. I mean, I'm not going to say we were happy with the prosecutors or the SEC, because we never are. We always want them to be more lenient than they actually are. It ended up with the monitorship being extended, and additional work for the monitor, which, you know, candidly, I suppose we were thrilled for, because it's business also. But it ultimately worked out in a way that was reasonable.
But the monitorship, sorry, can I just, the monitorship that's extended is obviously a cost as well for the company, and it's substantial still. How do you look at that? Because it is definitely not easy to have a monitor running around, physically running around in your company doing things. It is difficult, and I think that is interesting in terms of where you draw the line and say, okay, you have not fulfilled the agreement, you're just actually having a problem here, we'll extend the monitorship. But in what context would you actually start talking about we will also have more sanctions coming down the road?
Yeah, so first of all, monitorships are incredibly burdensome. I think in many ways, it's still worse, I think, to get prosecuted. But they're incredibly burdensome, and really, you know, they're very, very difficult for companies. And when I was joking, I was being flippant and joking about the business. You know, when I'm involved in monitorships, we try to be as fair as we can. We try to be as ethical as we can. We try to work with the companies to the extent we can. And as Adria emphasized, we really hate being proxies for the prosecutors, because that's not what we're about. As far as, I mean, the ultimate decision as to whether a monitorship is extended is really up to DOJ or the SEC. You know, a monitor can weigh in if it appears that the company under the monitorship is sincerely trying to fulfill its obligations. Then we do have the ability to make recommendations. But we try to be I have tried to be very, very judicious and careful about that.
Just a follow-up question. What situations would new misconduct result in the prosecution instead of just a prolonged monitorship?
Just depends, honestly, on the facts and the grievance and how the severity and also if it just depends on a lot. It's got to be pretty significant, I would think, under a DPA. And then before a judge for a plea agreement, it needs to be something that's going to make the judge question whether the company is being serious about its plea and what it agreed to. And I think you've seen a little bit about that maybe in the press with ZTE, which is a 10-year monitorship. ZTE is a Chinese-based company. And so they actually there was a lot of press here in the United States about how that monitorship, it seemed, was going to have to stop before it was supposed to end because the judge was so upset about certain things. But it just depends on all of the facts. And let me just say too, I completely agree with Barak about monitorships. I tell my clients a lot, I would never want them to be under a corporate monitorship. And, you know, I know I've been working for some of my clients for 18 plus years, and I know Volkswagen better than I know them. And that's crazy because I only was at Volkswagen for 3 years. So it's very invasive. It's very, it's costly. You're trying to run a business, and here I am asking you questions and observing meetings. And, you know, it's just, it's very, very tough. But I will say though, that it gives you some, if it works, right, and you do well and you make significant change, it does give you some confidence, and it gives your employees confidence that they're back on their way to working at a great company. And I think that is worth something. It gives the shareholders confidence. So that is worth something. And I agree with Barak, you do not want to litigate or be prosecuted for an FCPA action. I promise you that. It's, the consequences are dire, and it's not just money, by the way. You could lose your government contracts, you could lose your export licenses, your reputation. It goes on and on and on. So just sometimes, like Barak was mentioning, it's really about reality and trying to figure out the solution that works for the company at the time, and not really about, you know, in principle, do these vehicles actually work?
That's a great way, I think, to kind of encapsulate this with it. It's not just the compliance, it's really the whole look at the business and the sustainable business, from employees being proud to work for a company to the company losing multi-billion dollars of government contracts and more. But just to jump back to maybe what's a basic question. So Barak, early on you mentioned that you try to get clients into non-prosecution agreement rather than a deferred prosecution agreement. So just looking at the process, is that a negotiation that happens with the prosecutors early on? You like self-reported, or you know, otherwise you're otherwise in the crosshairs of the Justice Department, and that's when is that when you negotiate whether it's going to be a DPA or an NPA, and what does that look like? What's an NPA look like?
Well, I wouldn't say it happens early on. It starts happening well into the process. So as far as the company, from my perspective, when I'm doing the company, I'm helping the company with its self-assessment, and we're about to make a disclosure. We started looking at how bad is the problem? What kind of pitch can we make for our ability to remediate? Because what we want is a declination. We want DOJ or the SEC to step back and say, all right, you've got this. This is fine. You're under control. Thank you for disclosing. Declinations are rare. The government always wants its pound of flesh, even if you're self-disclosing, even if it's a problem you can manage. At some point in the process, the company and I are working together trying to figure out how bad can this reasonably get, and at what point do we have to fight it. Generally, you know, well into it, the discussion becomes whether we can get a DPA. As to whether it's a DPA or an NPA, NPAs are definitely preferable. There's no court involvement. It's a much more informal process. In substance, it's the same kind of thing. DOJ expects restitution, fines, expects certain kinds of ongoing compliance for a period of time, 2 to 3 years, typically 3 years. It's just the advantage is there's no court involvement. That's the difference. And the DOJ is likelier to want an NPA or agree to an NPA when the conduct is perceived as less egregious.
And the price tag is the same between NPAs and DPAs?
Comparable. I mean, at that point, it's already bad enough that I don't know that we sit down and look at all the data points.
It still requires a monitor. Does the NPA still require a monitorship during that period?
Theoretically, it could. I think you're going to see, more typically, you're going to see DPAs go hand in hand with monitorships.
Okay. Great. Thanks for clarifying that. So we have about 10 minutes left. So are there any questions here from the audience? Yes.
Yes, thank you for a very interesting discussion. So my question is from a U.S. perspective, is the Swedish corruption legislation functioning properly? And that would be in terms of its purpose and also in terms of the resources.
Thank you. Do either of you know enough about the Swedish legislation? Your question was about how it's from a U.S. perspective of Swedish legislation functions.
Just if it functions
Yeah.
in general.
Do you guys, Adria or Barak, do you know enough about Swedish legislation, know if it's functioning? Or to comment on it?
I think it's difficult for us to sort of compare it to the U.S., to be honest with you, as far as whether the Swedish anti-corruption law has the right purpose or resources compared to the U.S. from a U.S. perspective. Honestly, when I was listening to, or I heard that there may be a question about, you know, why is there more Swedish companies on the top 10 FCPA resolutions than others from other countries? Honestly, I don't think it's a Swedish problem. I don't think it has anything to do with the country itself. What it's more about is the industry. Telecommunications industries have a very high risk for corruption. And you know why? Because they want to be successful, they have to work outside of their own home country. They have to be international. Usually their customers are government entities or departments. They're going to have contact with government entities and departments. Therefore, they will have contact with government officials. It's just more of a high risk industry, just like the pharmaceutical industry, the oil and gas industry, and you name it. There have been many telecommunications companies on and off the top 10 FCPA resolution list, from Russia to VimpelCom, you know, you name it. So to me, it's not really about Sweden. It's really about the industry.
Hayaat, you want to say something?
I think we covered it earlier on.
Yeah, in terms of if it's working or
From a,
not,
yeah, from a Swedish
the answer is no,
perspective.
not completely. But we can always be better in terms of that. And I think that's one part, but the climate and the culture is changing, and also the discussions on the legislation and the need for stronger or more clear legislation in this point. I think that is growing. And we can see that also from a political point of view, that there's this is not the top of the agenda on the, you know, speaking about the upcoming elections. Obviously not the top of the agenda, but it's getting more on the top of the agenda because they can see links between corruption and some other failures in the Swedish society at this point.
Yeah, it's certainly like the topic that we're hearing more like in our conversations in Washington with legislators, in Brussels, in Stockholm, that, you know, talking about fighting corruption and standing up for the rule of law, promoting democracy, supporting a free and independent press. These are things that are now in sharp contrast since Putin's war of aggression in Ukraine. And I think we're hearing more and more business leaders speak out about how it's important to tamp out corruption. It's important for our concept of goal zero to reach the UN's sustainable development goals, but I think it's also important for sustaining democracy. Any other questions from the audience here?
I just want to go back to a first question and just ask you online here, you know, you mentioned that the national security was a new focus when it comes to anti-bribery corruption. How will that affect foreign companies?
It's an interesting question. I've been wrestling with that. I'm not sure. Candidly, I'm not sure it changes that much. I like the way Adria put it. It's a national security is easy to sell when you have a fractious Congress. So that's a very easy way to frame it. You know, early on in my career, I was involved in defending alleged violations of the UN Oil for Food program. And so clearly that's a way of that was one way of framing anti-corruption in terms of national security. The same kind of issue could pop up again today, you know, anti-corruption with respect to sanctions regimes or areas where there are sanctions. But I think the same risks for companies that existed before this became a national security issue exist today. Framing it as a national security concern, I think, is primarily about consumption to U.S. legislators.
And I also think too, for many years, I would hear from my smaller clients, well, I'm not Ericsson, I'm not Airbus, I'm not, you know, these big companies, they're not going to go after us. You know, we're such a, you know, we're so low on the totem pole, or just not going to be the focus, right, of the DOJ. And that changed somewhat because years ago, Smith & Wesson, the gun manufacturer, actually got slapped by the SEC for an FCPA violation. And it kind of woke up my smaller clients. But now that they hear it's a national security issue and there's going to be more funding for more agents and more resources, now they're thinking, you know what, maybe it doesn't seem so far away. Maybe that actually could be a possibility that they're coming after smaller companies too. So that's the only real change I've heard from my clients, really.
Just another question in terms of, you said it was the industry that was not particularly related to countries or foreign national or other countries than the US. But if you look at the statistics, and I don't have that, that's why I'm asking you, what's your recognition of American companies? Are they overrepresented under these DPAs or more foreign companies?
I would say, I haven't looked at it lately, but Barak, my last time I looked at it was more foreign countries. And actually I read an article the other day that companies based outside of the U.S. actually pay higher fines than the ones based in the
we noticed that one. Yeah.
Yes. And I have to tell you, I'm not surprised, because I don't think the DOJ is actually putting together a consistent method. Because when I go in there to negotiate these things like a DPA or an MPA, you know, I'm taking all of the latest resolutions and then we have like a spreadsheet, and I'm trying to figure out where I can slot my client in there with regard to fines and years and all of that sort of thing. There's no consistency, okay? And sometimes it's about the company just wants it to end and they just want a resolution. And so they're willing to take something that maybe my client would not take. Barak, do you have anything to add there?
Well, I agree completely. The lack of method is frustrating, but what's probably more frustrating is hearing prosecutors claim there's a method, and they're not just going to make back of the envelope calculations, and then realizing during the course of negotiations they're really just making this up as they go along. Like we are struggling to find a principled way to come to some sort of resolution, and looking at all these data points. And they're essentially sticking their fingers up in the air, and feels like this. This is what we can get from you guys. Very frustrating.
Yeah, just a follow up there. The U.S. authorities, are they unfairly then going after foreign companies? Would you say that? I think that's something some are asking themselves here in Sweden.
So I think,
yeah, they're targeting more foreign companies than U.S. companies.
I don't know if they're targeting more foreign companies. I think they're getting different kinds of resolutions. It can be harder. Jurisdiction's obviously an issue, because this whole panel, to some extent, is about extraterritorial application of U.S. law. So if you're going to go after a U.S. company, you are far likely to, in my opinion, you're far likely to see an effort to prosecute aggressively, and that's just not as easy to do with a foreign company. By prosecute, I'm talking about post-indictment litigation. That's easier to do with a U.S. company.
So it's a win-win for both, in the sense that you don't need to prosecute, spend all that time with the stick with the prosecutor, the foreign company, and the foreign company can get out of it quite quickly by paying.
I think that's the perspective, whether it's clearly thought out or not. I think there's a certain kind of efficiency. DOJ recognizes there are jurisdictional challenges. There is also an understanding that they have a lot of leverage if foreign companies wanting, and this is the piece that goes to the unfairness of it. I think they understand that being involved in the U.S. is, if you're a multinational, there's an inevitability to being connected with the U.S. at some level. So DOJ and the SEC have some leverage. And if you're a foreign company, as many of my clients are, then you really just want to get out of it and be able to do business. And so you're asking yourself, is there a practical way that we can limit exposure here and still limit the reputational damage, and then extract ourselves from the situation?
And then how do you just, because we're running out of time, so, but just briefly, other than just general compliance, what's the best way to avoid getting into trouble with the DOJ to begin with?
Behave. Behave.
I would say,
Well,
I think the
so-
statistic is, well, I would say that the statistic, I think is still true, that over 90% of FCPA cases involve third parties. So your vendors, your consultants, you know, your third party agents, you really need to understand who they are and you need to monitor them because that is where most of the risk resides. And it is costly to do that and it is a pain to do that, but it is imperative if you're in a high risk corruption industry or you're doing business in high risk places. You really need to understand and know what your third parties are doing on your behalf.
That makes
I think
sense.
that's exactly right.
And I think it's also part of the investment of the companies need to spend money before it's too late. As you said, it is possible to have your own compliance, build compliance, but that is an investment. As much as you do research and others to develop new products, you need to invest in this now. And that is, I think some companies have understood that more than others.
Well, they're gonna have to do it regardless of whether it's for like compliance when it comes to
Absolutely.
corruption, but also sourcing, supply chains, like, so. Yeah, great. Well, I think, we could obviously talk about this for quite some time, but we've reached the end of our time together. And I want to thank you guys for joining us this morning from Atlanta and Washington. And thank you two for being on stage, and thank you all for joining here in this meeting.
Yes, thank you.
Thank you.
Thank you.